So once you're arrested for DUI in Georgia, the police officer will read off of an orange card, which is called the Implied Consent Notice. Georgia says that any driver who drives on our highways impliedly consents to the giving of a state-administered chemical test of their breath, blood, urine, or other bodily substance to determine the presence of alcohol. So what happens is the officer will place you under arrest and read off of an orange card. Now, the implied consent, there are three types of implied consents depending on whether you're under the age of 21, over the age of 21, or whether you're driving a commercial vehicle. The most common one, of course, is you're driving a vehicle and you're over the age of 21. The implied consent warning is basically this. Georgia law requires you to take a state-administered chemical test of your breath, blood, urine, or other bodily substance for the purposes of determining if you're under the influence of alcohol and drugs. If you refuse to take this test, your license or privilege to drive will be suspended for a minimum period of 1 year. The refusal to take any test may be introduced into evidence at trial against you. If you take the test and you register above a .080 grams blood alcohol, your Georgia license may be suspended for a minimum period of 1 year. After first taking the required state test, you are entitled to an independent test of your own choosing by qualified personnel of your blood, breath, urine, or other bodily substance. Will you submit to and then they'll usually designate a test of your blood, breath, or urine under the Georgia Implied Consent Law. Now, three things to remember about the Implied Consent Law. First of all, the implied consent is supposed to be read after the arrest, not prior to the arrest. And it needs to be read at a reasonable time within the arrest. There have been cases in Georgia that say that if the implied consent warning is not read at the time of the arrest, then any tests given are not admissible against you. But there have also been cases that say even up to 30 or 45 minutes, depending on the circumstances, the state test may still be used into evidence against you. The other thing to remember is that you are not entitled to talk to or call your lawyer to ask if you should submit to the state-administered chemical test. Some states, and I think Canada, allows one telephone call to an attorney, but Georgia is not one of those states. You are not entitled to actually call anyone and ask whether you should take the test or not. The police officer now does not have to designate which test. He can just read the card and then decide later on whether you should take a breath test, a blood test, urine, or all three. And the other thing to remember about the implied consent is you do have the right to refuse to take the state chemical test. However, there are consequences or possible consequences if you do refuse to take the test. That's called an administrative license suspension, and that's a topic for another video. But that's the implied consent warning, and basically the procedure is once you're placed under arrest for DUI, the officer reads you an implied consent warning, and when he or she gets to the end, they're going to ask you to submit to a state chemical test of your blood, breath, urine, or other bodily substance to determine if you are under the influence of alcohol or drugs.